The answer is D, both A and B option combined. The Chief Election Commissioner (CEC) of India can be removed from office by a resolution passed by both houses of parliament with a special majority of two-thirds members present and voting, supported by more than 50% of the total strength of the house. The resolution must be initiated by the President of India. The special majority requirement means that at least 266 members of the Lok Sabha, the lower house of parliament, and at least 126 members of the Rajya Sabha, the upper house of parliament, must vote in favor of the resolution. The grounds for removal of the CEC are proved misbehavior. Incapacity. The CEC cannot be removed from office simply because the government or the ruling party does not like his or her decisions. The removal process is designed to protect the independence of the CEC and to ensure that he or she can carry out his or her duties without fear of political interference. The CEC is appointed by the President of India, in consultation with the Union Council of Ministers. The CEC has a fixed tenure of 6 years, or up to the age of 65 years, whichever is earlier. The answer is C. Sukumar. Senator Sukumar Sen was the first Chief Election Commissioner of India. He served from the 21st of March 1950 to the 19th of December 1958. He was responsible for conducting the first general elections of independent India in 1951-52. The other options are K.V.K. Sundaram. He was the second Chief Election Commissioner of India. He served from 1958 to 1967. M. Patanjali Sastry. He was the fourth Chief Election Commissioner of India. He served from 1967 to 1972. S. P. Sen Verma. He was the seventh Chief Election Commissioner of India. He served from 1972 to 1973. I hope this helps. The present Chief Election Commissioner of India is C. Rajiv Kumar. He assumed office on May 12, 2022. He is the 25th Chief Election Commissioner of India. The other options are Sunil Arora. He was the 24th Chief Election Commissioner of India. He served from 2018 to 2022. Sushil Chandra. He was the 23rd Chief Election Commissioner of India. He served from 2020 to 2022. Om Prakash Rawat. He was the 22nd Chief Election Commissioner of India. He served from 2018 to 2020. I hope this helps. The emergency provisions of the Indian Constitution have been borrowed from the A. Germany. The Weimar Constitution of Germany, which was adopted in 1919, had a number of emergency provisions that were designed to deal with threats to the stability of the state. These provisions were used by the Nazi regime to consolidate its power and to suppress dissent. The Indian framers of the Constitution were aware of the dangers of these provisions, but they felt that they were necessary to protect the country from external aggression and internal subversion. The emergency provisions in the Indian Constitution are divided into three categories. National emergency. This is declared by the President when the security of India or any part of its territory is threatened by war, external aggression or armed rebellion. President's rule. This is declared by the President when the state government is unable to function effectively. Financial emergency. This is declared by the President when the financial stability of the country is threatened. The emergency provisions have been used by the Indian government on a number of occasions, including during the Indo-Pakistani War of 1971 and the emergency of 1975-77. The use of these provisions has been controversial, and there have been calls for them to be amended or repealed. The other options are Japan. The Japanese constitution does not have any emergency provisions. USSR. The USSR had a number of emergency provisions, but these were abolished after the collapse of the Soviet Union. USA. The USA has a number of emergency provisions, but these are much more limited than those in the Indian Constitution. The answer is C. 3. There are three types of emergencies mentioned in the Constitution of India. National emergency, Article 352. This is declared by the President when the security of India or any part of its territory is threatened by war, external aggression or armed rebellion. President's Rule, Article 356. This is declared by the President when the state government is unable to function effectively. Financial Emergency, Article 360. This is declared by the President when the financial stability of the country is threatened. The national emergency and President's Rule can be declared by the President on the advice of the Union Cabinet. The financial emergency can be declared by the President on his own. The emergency provisions have been used by the Indian government on a number of occasions, including during the Indo-Pakistani War of 1971 and the emergency of 1975-77. The use of these provisions has been controversial, and there have been calls for them to be amended or repealed. The code you wrote to calculate the number of emergency types in the Indian Constitution returns the correct answer of 3. However, it is important to note that the emergency provisions are complex and there are a number of other factors that need to be considered when determining whether or not an emergency has been declared. The correct answer is D. Article 360. Article 360 of the Constitution of India deals with the provisions as to financial emergency. It states that the President can proclaim a financial emergency if he is satisfied that a situation has arisen whereby the financial stability or credit of India or of any part of its territory is threatened. The President can declare a financial emergency on his own, without the advice of the Union Cabinet. However, the proclamation must be laid before both Houses of Parliament within 2 months of its being issued. The proclamation ceases to operate after 2 months unless it is approved by resolutions of both Houses of Parliament. The President can also issue directions to any state to observe such canons of financial propriety as may be specified in the directions. These directions may include reducing the salaries and allowances of all or any class of employees serving in connection with the state of affairs, controlling the issue of money, regulating the borrowing of money, requiring the states to take certain steps to improve their financial position. The financial emergency provisions have been used by the Indian government on a few occasions, the most recent being in 1991. The other options are Article 150. This article deals with the powers of the President to make ordinances when Parliament is not in session. Article 352. This article deals with the declaration of national emergency. Article 356. This article deals with the imposition of President's rule in a state.
Which among the following article gives the power to the central government to take preemptive action to protect any state against the external aggression and internal disturbance? Article number 355.
Yes, Article 355 of the Constitution of India gives the power to the central government to take preemptive action to protect any state against external aggression and internal disturbances. Article 355 states that it shall be the duty of the Union to protect every state against external aggression and internal disturbance and to ensure that the government of every state is carried on in accordance with the provisions of this Constitution. This means that the central government has the responsibility to protect the states from any threat, whether from within or outside the country. The central government can take any steps that it deems necessary to fulfill this duty, including sending troops to a state to quell a disturbance, providing financial assistance to a state to help it deal with a natural disaster, intervening in the administration of a state if the state government is unable to function effectively. The central government's power under Article 355 is not unlimited. The central government can only take action if it is satisfied that there is a threat to the security of the state or that the government of the state is not functioning effectively. The central government must also take into account the views of the state government before taking action. Article 355 has been invoked by the central government on a number of occasions, including during the Kashmir insurgency and the Naxalite movement. The use of Article 355 has been controversial, and there have been calls for it to be amended or repealed. I hope this helps. The word enact means to make into law. So the answer is B. The other options are single chapter. A chapter is a part of a book or other written work. It is usually a self-contained unit that deals with a particular topic. Single action. An action is something that a person or thing does. It can be a physical action, such as walking or talking, or it can be an abstract action, such as thinking or feeling. Rectify the mistakes in the law. To rectify something means to make it right or correct. In the context of law, this means to fix any mistakes that may have been made in the law. I hope this helps. The Election Commission of India (ECI) does not conduct the election to the office of the Speaker of Lok Sabha. The Speaker of Lok Sabha is elected by the members of Lok Sabha themselves. The ECI is responsible for conducting elections to the Lok Sabha, the Rajya Sabha, the state legislative assemblies, the state legislative councils, and the offices of the President and the Vice President of India. The other options are the Office of the President. The ECI conducts the election to the Office of the President of India. The President is elected by the members of the Electoral College, which consist of the elected members of Parliament and the elected members of the legislative assemblies of the states and union territories. The Office of the Vice President. The ECI conducts the election to the Office of the Vice President of India. The Vice President is elected by the members of Parliament. State legislature and union territory. The ECI conducts the election to the state legislative assemblies and the union territory. The state legislative assemblies are elected by the people of the state, while the union territory are elected by the people of the union territory. The correct answer is D. Indefinitely. Once the proclamation of financial emergency is declared or approved by the Parliament, it continues indefinitely until it is revoked by the President. There is no maximum period prescribed for its operation. The President can revoke the proclamation of financial emergency at any time by a subsequent proclamation. However, such a proclamation does not require the approval of Parliament. The financial emergency provisions have been used by the Indian government on a few occasions, the most recent being in 1991. I hope this helps.